Hello, everybody. Welcome to this week's edition of Global Lawyers of Canada Virtual Mentor Office Hours. Tonight, we are joined by Sam Gebrael, hoping that I pronounced that right. Sam is an internationally trained lawyer. He is dual called in New York and Ontario. He is the practice lead with a civil law, with a litigation practice in Ontario. He is also one of the co-founders and co-president of Global Lawyers of Canada's Ontario chapter. So he's also going to tell you a little bit about what Ontario's up to. He's going to share with you some various different things. But first of all, Sam, thanks so much for joining us tonight. We're really excited to have you and to have you share all of your tips and your journey and your experience with everybody. But why don't you go ahead and introduce yourself to everyone? Tell everyone a bit about your story, your journey.
Sure. So officially, Samir Gebrael. In Canada, Sam Gabriel. All right. Basically, I'm essentially, if you want to go all the way back, I'm an immigrant, but I came to Canada when I was 11 years old. A lot of the stories of, the ITLs, I know they are immigrants, so I can definitely connect with them on that level. Some of them are not, but I think a lot of them are. So basically my legal journey starts, a decision basically to go to New York, to go to law school there. The reason I ended up choosing New York was I thought, well, I wanted to be a commercial litigator, and I thought, what a better place to be, to do commercial litigation and commercial law than, the heart of, right, the commerce, New York City. And so I ended up there in 2004. 2007, I graduated from law school in New York City. I worked there for about 3.5 years, and I came back to Ontario, thinking, of course, that, once you make it in New York, you can make it anywhere. Little did I know that that's not really true. And, that Ontario essentially, the Ontario lawyers, they feel like, a lot of them, not everybody, but a lot of them felt like, you know what, if you haven't practiced in Ontario, then you really haven't practiced law at all. And I found that I have to go, going back to 2010, 2011, I found that experience, coming back. I'll admit, I probably, if you had asked me about 3-4 months after coming back from New York, I would probably have told you that coming back was the worst decision I've ever made in my life. And maybe some of you are feeling that way right now, right? Like, what did I do to myself, right? I was a lawyer. I don't understand how everybody thinks I'm no longer a lawyer now. So at the beginning, I felt like this was the worst thing I've ever done. What did I do to myself? Thinking maybe I should go back now. But, I slugged through it. I got, I did my NCAs. That was about a year process. And then I passed the bar. And I thought for sure, right after I passed the bar, the doors are going to open. No, they didn't open. Nothing opened yet. And I kept looking, and I was like, and I met with a lot of people. A lot of lawyers they're nice, and especially in the summer, they have time. So everybody was pleasant, able to meet and ready to meet and provide advice. And I was very grateful for that. But nothing was opening at all. Like, everybody just kept telling me, that's great, but you don't have Canadian experience. I was like, yes, but I can't get Canadian experience unless I start. And probably all of you have experienced that. And so probably within about, after 6, maybe it was 3 or 4 months after I officially was licensed, I basically said, you know what, I'm just going to volunteer somewhere. And I ended up volunteering at a law firm for no pay. I don't advise that for anybody, but I'm just telling you what I thought I had to go, what I thought I had to do. And because, I just got really bored. I'm like, I can't sit at home anymore, right? I'd rather just volunteer than just sit at home. Within about a month, though, the firm then ended up hiring me. And then 3-4 months, just because as soon as I got my foot in the door, and as soon as I had on my resume that I was actually employed, then the firms essentially treated me differently. Oh, he's an Ontario lawyer now, oh, he's working now. It's a whole other way that they look at your resume. And then, thankfully I also got a really good job within 3-4 months at a very big law firm. I stayed there for 4.5 years. After that, I worked downtown for a couple of years. And then just about a year ago, I basically decided to start my own firm, and it's been going, thank you. Yeah, so basically I have I should say it's my own firm, but essentially it's a branch of an existing firm. So it's my own branch of an existing firm. I retained one NCA student about a year ago, and just literally a few days ago, Jawad joined me, and so yeah, things have been really good. I should add, I think 1 or 2 of the people here actually applied, and I'm really grateful for your applications as well. Unfortunately, I was only able to take 1 person at this time, but I have to say the quality of the applications and the quality of the resumes I got, it was really difficult. Jawad, you just slipped through, like, I'm not kidding by saying this, you really just slipped through like this. One spelling mistake, Jawad, you may not have been able to make it through. Actually, Jawad, you did not have any spelling mistakes. I was very impressed, by the way. I actually looked for that. I did. So that's my story in a nutshell. So here I am, kind of full circle, able to then, bring in NCA students and help them get the experience they need to break through the market. Something that, I'm so grateful that I'm able to do. So yeah, this is really full circle for me.
That's absolutely fantastic. And it just goes to demonstrate the absolute level of caliber that the internationally trained lawyers have, when it's that close between who you could potentially hire and that you had multiple options.
Yes, yes.
Not to do any disservice to Jawad because he's the one that you took, but there are multiple candidates out there. He's not an anomaly, is what we're trying to get at.
Very true.
Hopefully more lawyers will see this and will see the opportunities there in the future. And that's part of what GLC does. And I'm so glad that, Sam, you're in the position where you're now able to help the next group of people come through in various different formats by either offering employment or mentoring, or even just with GLC as well. So that's great to have you on board. So my next question for you is, were you always interested in commercial litigation? Did you always know that's what you wanted to do?
I think I did. I think going down to New York City really cemented that for me. Although my career was not always a straight line, I started off doing initially what I thought I was going to do was securities litigation. And securities litigation is like, it's very sexy. You think, oh yeah, I'm going to be suing these, as either representing shareholders, suing a company, or maybe helping some shareholders take over a company. Securities litigation, it sounds really funky. And I thought I'd be doing that, but then that was never, and then I ended up leaving the initial firm. So yes, I think I always wanted to do commercial litigation, but it was never a straight line. So for years, I ended up doing insurance defense. But in hindsight, looking back, although I thought maybe at that point it was kind of a step back, in hindsight, all those positions that I ended up taking were actually really just building blocks, gave me the experience that I needed, and to be more confident as a commercial litigator going forward. So that's kind of the advice that I would give all the commercial litigators. If you want to be a commercial litigator, just because the first step doesn't sound like 100% commercial litigation, it doesn't mean it's not going to give you some very valuable skills that you can use going forward. Now, if you're fortunate enough to land your first job and it's commercial litigation, that's great. But they're not always available, and they're hard to come by, pure commercial litigation positions.
So that actually segues beautifully into our next question, which is, how have you adapted your career over the years to find your niche, and particularly now with the specialism that you find yourself doing? Can you share how you've done that?
Right. So initially, So as I was saying before, initially I started out thinking, yes, for sure, I'm going to end up, being a commercial litigator. But then after, entering into other areas, and I was Gowlings at 4.5 years, and I don't say that to impress you, just to impress upon you, sometimes when you're at not just big firms, any firm, when, the partner at the firm says, hey, do IP litigation, you go, sure, I'm going to do IP litigation. And I did IP litigation. I did insurance defense. I can't think of an area of law other than obviously criminal law, but in the civil litigation world, estate litigation, I don't think I can think of an area that I didn't probably touch upon at some point. But over the years, and I think this is another thing that I think that as your careers progress, you have to kind of look at what the market is asking from you. You have to kind of be open to what the market is asking for. And I felt like all the clients that I would take on, a lot of their problems involved property litigation. Whether it's directly because they have a property and they're trying to purchase it and for some reason they cannot purchase it, or whether it's indirectly as in their shareholders disputing a piece of property. Basically it's more like an oppression remedy where there's two shareholders and they have a property and one is disputing over which one should have the property. But essentially at the end, it ended up being that a lot of these disputes involved property. And so I listened to the market. I listened to what my clients wanted. And so that started naturally gravitating to that area and just specializing in that area. And I'd say in the last 3 years, probably 95% of my work has just been in that area. It doesn't mean that I don't take on other work, not in that area, but I try to stay in that lane. But there's so much to do, right? I mean, in property litigation, there's so much to do. There's disputes between condo corps and, condo owners. There's just, aborted sale transactions, or you could go on. So even that area, which I kind of specializing in, it's so big as well. So I haven't narrowed it down too much, which I also feel like sometimes when people do that, that might be a disadvantage to them.
Absolutely. And have you found that there's been a lot of transferable skills from all of the different experiences you've had and all the different types of litigation you've done, and that they've all helped overall?
Yes, definitely. So one of the things that I really appreciated about doing insurance defense is in insurance defense, you get a lot of time doing discoveries. So when I say insurance defense, I mean like I represented, for example, RBC, Gore Mutual, some of these insurance companies on everything from a motor vehicle accident to slip and falls to a construction site where the construction workers got hurt, or a construction site where the job that they were trying to finish went sideways and actually the side of the house collapsed. So yeah, basically the entire spectrum of insurance defense files. And the great thing about that is that you get to do a lot of discovery. And that's not very common in commercial litigation. Commercial litigation, you have very few files, bigger files, and sometimes you're even dealing with them without actually true discovery. You may be dealing with them just through maybe expert reports and getting some kind of financials together, although most of the time you do discovery, but they're not as common, and the files don't move as quickly. So looking back, I probably did, in the 2.5 years that you can say I was almost 75% of my work was in insurance defense, I probably did a discovery once a week. But that's so rare now. Looking back, I'm so glad that I did it, because now when somebody says, okay, go do this discovery, I'm like, yeah, I've been there so many times. It's great. But I would say in my commercial litigation files now, I could probably maybe do a discovery once a month, maybe once every 2 months. I'll get to another discovery. So definitely there's areas of law, if you can get into them, you can gain certain skills very quickly versus other areas where you're just not going to get those type of skills, and they're definitely transferable.
Fantastic. And that kind of brings me to our next one, which is, did you find that your experience in the US and the work you did there, has that been useful for you now? Has it transferred across? Or have you found it's been extremely different and you really haven't used it as such?
Good question. So initially, if you had asked me that question when I first got back, I would have said, you know what? I think I wasted 3.5 years of my life. All right. Like, I just felt like nobody's acknowledging this experience. It seems like I don't know the first, like, you know, like even some of the basic terms. Um, Factums, like we didn't even have factums in New York. We didn't even know what that is. So people tell me factums, I was like, I don't even know what that is. But then as your career progresses, you realize actually there's all these connections, and you realize where these things are similar and how they're different, and there's some differences. But then you can start connecting the skills, and you can start connecting, okay, well, actually all they mean by factum is the argument section of a motion. And so, okay, I know that. I've done motions in the US, and I did argument sections in a motion. We just didn't call them that. It was called something else. And you then, and also by having the skills from another jurisdiction, for example, in the US, they have subpoenas to get evidence. In Canada, we don't have that. But actually what it did, and so when you have to get, so in Canada, you know, everyone knows here is that you basically just exchange affidavit of documents, which is so nice because basically the other side's telling you, here are all the documents laid out for you, essentially in a nice list, all the relevant documents. In the US, you don't get that. You basically have to ask for documents and then keep asking for more documents until you get all the documents you want. Now, sometimes in Canada, that might happen if the other side's kind of being a little tricky and they don't actually produce all the relevant documents, but it shouldn't happen. But by practicing in the other jurisdiction and by practicing that kind of that skill of thinking of what the relevant documents are and trying to draft a subpoena for certain documents, so it gave me that kind of skill of to think like, you know, what should we be asking for? So in case the other side in Canada and Ontario is trying to be a little tricky and you know they do not produce the relevant documents, then I know maybe what questions to ask. So it definitely did help out. Now, I would say most of the skills helped, but or you know, so, I don't know how to say most. I think I have a number, but I can look back and say yes, some of the substantive law, like I learned a lot about Chapter 13 and Chapter 11 restructuring in New York City. I learned a lot about that. Now, can I apply it in my practice today? No, but you know, it is what it is. And although sometimes I do have certain clients, they may have an issue and they'll talk about Chapter 11 and kind of it's impressive to be like, yes, of course, I've done Chapter 11 restructuring, sure, you know, in New York City. But other than that, for sure, some of the areas do not really you know, translate, but a lot of the actual skills are very helpful. And I'm sure whether you're coming from Bangladesh or another jurisdiction, there's going to be a lot of that transfer of skills. You just need to then connect them and understand how everything connects. And once you understand how everything connects, you become a very good lawyer, and maybe even better because you understand the distinctions and how those distinctions matter and how you can apply them even you know, in the best way possible.
Absolutely. And you make a valid point about, you know, used example of Chapter 11 and Chapter 13, but the fact that you were able to learn that regulation, those rules, and then interpret them and apply them shows that you can do that again. And you've obviously done that in Ontario, and you've been able to use that ability to learn. And Chapter 11 and Chapter 13 are not simple and straightforward. They are very complicated. So the fact that you've had that ability where you've taken something that's really complicated and been able to interpret it and apply it means that when you come to a different jurisdiction, you have that ability to do it again, just with a different rule book in front of you.
Yes, totally agreed. And that's, I mean, that's one of the things about ITLs, and one of the things that, you know, I always tell people about ITLs, and these are individuals that were able to learn other, entire other laws of other countries. And now I've come back and learning another law of another country. The fact that they were able to learn this other law and now relearning it again, it shows so much resilience and just, I think it's such a positive. And this is one of the things we're trying to do with GLCO and GLC, right? I mean, change that mindset with people. I wish we had this in 2010, 2011 when I was kind of starting out, because we didn't have this. And when I started out in 2010, 2011, I almost didn't want to tell people that I was an ITL at all. And I kind of like, I just kind of said, well, yeah, I went to Canadian school, like undergrad. So I kind of played that up. I didn't want to tell them about my law degree.
I feel you on that, but I didn't even have a Canadian undergrad. I just kind of glossed over that part.
Oh, okay.
Yeah, I definitely.
Where did you go to the undergrad?
I did my undergrad in the UK. So
okay.
Yeah, because that's where I'm originally from.
Okay.
The accent carries these days. But yeah, I've definitely been there, and I'm sure others have been there too, where you try and gloss over bits of it. But I do feel that's changing now. I do feel that the perception is starting to change, and people are a bit more open and talking about their different backgrounds and different journeys and experiences. Or maybe it's just because we're in the GLC world, so that's what we do every day.
I always wonder the same thing. I wonder, is it changing, or is it because we've created this what do you call it, this biosphere almost, right? And we're inside the biosphere. I always wonder the same thing, whether it is actually changing. And whether maybe just because all my LinkedIn connections, or a lot of them are ITLs, so I'm hearing all this positive news, right?
Yeah, absolutely. It'd be interesting to see. I wonder if we could get someone to do some research on that for us, because it'd be intriguing to see what's going on outside of our sphere, for sure.
Yes.
So now you're doing real estate litigation. That's predominantly your focus at the moment. How has COVID impacted this for you? Has it impacted at all?
Sure. So at first, when COVID happened, actually, I had a hearing the day that the emergency declaration actually took place. So March 16, I had a hearing, actually, I think it was on that day or the day after that. And I actually did not show up to the hearing. And the reason being, unfortunately, my father-in-law is actually going through cancer treatment. And my wife was very, very scared, if I would catch it. And obviously that would, means, potentially infect my father-in-law.
Yeah.
And so I wrote opposing counsel an email saying, I can't show up to this hearing. I can't, I'm sorry, just tell the judge I can't. And I thought for sure, that's it. We're not going to be doing anything for the next 2-3 months. And I thought, okay, well, I guess I'm going to have some time off. That's good. I'm usually a busy guy. It's good to have time off. And then to my surprise, within a couple of weeks, actually all these issues related to COVID, that I would say not related to COVID, but were caused by the impact of COVID, and specifically the restrictions imposed by the government due to COVID, started to pop up. And because I'm in this area dealing with a lot of property and tenant, commercial landlord-tenant issues, you saw a lot of these, for example, tenants wanted to get out of their lease. They thought, oh, well, now it's, it's COVID. I don't have to pay my rent. I'm just going to walk out of my lease. Or, real estate transactions where people were like, well, I'm not gonna get, I don't have to actually close on this transaction because COVID. Everybody just kept on saying COVID, and I don't have to close COVID, right?
Yep.
The reality is it's far from that. Like most of the contracts, actually, COVID or no COVID, you're gonna still have to close. And so I did field a lot of calls initially that went nowhere. Right? Like I'm like, no, it's just because you got COVID doesn't mean you cannot, you don't have to pay your rent. Unfortunately, actually, most rental agreements, commercial rental agreements, specifically say even if it's pandemic or whatever it is, you still have to pay your rent. So I'd say I was busy in a sense, fielding a lot of calls, but still my practice kept probably at a steady pace. I didn't get busier, but I kept at a steady pace. But what ended up happening is a lot of the other files that were not very urgent actually all got pushed back.
Right.
So in some ways, actually, it actually was it was a benefit for me. So because I had all these issues that now I got busy doing COVID related type of work, but then all my other files now have been pushed back until September. So actually now I have a larger flow of work, which is, I'm like, okay, well, turned out to be okay with me.
Yeah.
Now I'm hoping that clients are going to be able to pay, because obviously with COVID, and I'm being a bit facetious here. I mean, it is a serious situation here because a lot of these clients are suffering, and that's a major problem. But
that's great though. I mean, it's nice in a way to have that pipeline of work now because it was delayed. You have that.
Yeah.
I mean, there are obviously consequences that you don't know about, you know, whether they're going to be able to pay the bills on those files when they come to the front. But it's nice to already have that there, sitting there, so you've not got to go out and like find new business. And especially in September, where September is traditionally can be a little bit slower as well, because everybody comes back from vacation from August, where for those of you who haven't been practicing for long in Canada, typically everyone vanishes in August. Like,
yes,
it just goes really quiet. That's not the case for me. I'm probably going to have my busiest August of my life. And I'm sure, Sam, yours is looking to be quite busy as well, because we've had that delay of work, and now boom, here we go. Let's go.
Yes. Yeah. Yeah, I am expecting September is going to be busy.
Yeah.
I'd say, but you're right. Like not probably until September 10th, like right Labor Day.
Yeah.
Then it's going to be like probably beginning of September. We're still going to be slow. August should be slow, although my August is probably going to be busy.
Yeah.
But yeah, and this is, I guess, an advice to all the, everybody here, is that traditionally with larger firms, even mid-sized firm, August will be slow. So if you're out there looking right now, don't feel kind of, despondent, and don't despair if not a lot of people are looking, or especially if nobody's posting for any job postings. I mean, COVID has not helped the situation especially for a lot of large firms. I've heard it's been slow out there. But especially in August, as you said, I mean, lawyers, that's like our only month that we kind of take a step back a little bit, is August. I'd say August and maybe beginning of January a little bit, we step back and take some time off. And it's funny because I saw, the statute of limitation has been extended, and the law, is extending all statute of limitations because of COVID until September 11th. And I'm like, I'm sure whoever passed that law was like, yeah, you know what? Usually we don't do anything until September 11th anyway. So let's just extend them until September 11th, give some time, give everybody a little bit of break.
I saw that too and felt the same thing. I was like, oh, that person's got some vacation coming up. There we go.
Exactly.
Yeah, I do feel that. I do feel that if you're reaching out to people right now and they're not responding, one, they're probably just flustered because of everything that's going on in the world, but also August is the month where everyone disappears. They don't have childcare because traditionally you would take August off, or at least parts of August. So they've got no childcare set up. And they typically, if they have a second home or they have rented somewhere, they go and they leave town. And it's the one time where everyone puts their phones to the side. I know I'm doing it next week. So I'm a prime example of this happening. But have you found that the way you've been working during the pandemic has changed? Like, have you been doing online court? Have you been doing virtual hearings and things like that? Or is your caseload at such a point where you've not had to do that because it's preliminary at this point?
That's a great question. So that actually is one of the biggest changes that I've had. So I've always been the traditional, go to the office kind of guy. I remember having multiple arguments with my wife about why is it that you can't work from home, and I'm like, it's impossible. How can I ever work from home? The computer is slow, and you name the excuse I've probably come up with. And because of COVID, like literally I've been at home since March 16th. I probably now in the last couple of weeks, we started going back a little bit to the office. Now I probably go in 2 days a week. But I have to say, like, the days I go in, I'm thinking, do I really need to go in today? Like, I'm questioning, why is it that I'm going in, you know? It's like, yeah, I guess you kind of have to go in, but I'm just amazed by how much, like, that attitude has changed. And it really made me think about, what am I doing differently, and what else am I doing that I'm just doing because I thought it was just the way it had to be done. And it actually really is making me think about long term, you know, the future of practice, of legal practice, and firms, and do we really need space? Do we really need such big, like, you know, commercial space to practice law? Because that's traditionally been one of the biggest costs for lawyers, right? They have, like, you know, I worked at Gowling's downtown. You know, they have like four floors at First Canadian. I cannot imagine how much they're paying for that space. Do you really need all that space? And if you can take that cost away, maybe you can translate it to, you know, more reasonable prices for your clients. That actually made me really rethink the way that we practice law and the costs involved. And that's definitely going to impact, you know, the way that I the way that I build my practice going forward.
That's really interesting. I've heard that from a few people too, where they were similar to you, where they were like, no, I must work in my office. I need to be here. I need to have that space. And maybe if, you know, the pandemic had only been for a few weeks, maybe we would have still felt that way. But as you say, it's been, you know, what are we on, 3 and a bit months, almost 4 months now of this remote working, hybrid working, whatever situation. And I think you're right. A lot of people are seeing that same idea. And, you know, for you particularly with what you do in real estate litigation, I can see there being more and more incidents where you're being involved for your clients because people are trying to break those leases as they realize they don't want that huge overhead. Because as you say, that factor, when you break it down, you know, per square foot, per body that you have in there, and the number of hours they have to work to produce money to cover that expense is significant. Whether you're in the downtown GTA or the downtown Toronto, or you're further out in the GTA somewhere, it's, you know, the comparison to what you're bringing in the door is sizable.
Yes. Yeah, totally agree. And I think a lot of firms are considering that and kind of rethinking the way that they're going to be practicing going forward. And in some ways, the firms that cannot do that because they're very traditional may be at a disadvantage. And so that may give us an opportunity, as, you know, in some ways, like if you think of ITLs, we always think outside the box because we've had to, right? We've had to kind of rebrand ourselves and think outside the box. So maybe that's something that we should be thinking about as ITLs. You know, how can we use that to our advantage now?
Absolutely. Yeah, there you go. Everyone think about that. We'd like your comments. We'd like your feedback on that question, please. Definitely. And I'm going to throw you on the spot here. This is not one of the questions that we pre-thought of, but on the same vein as that, if we're going to a more remote working, flexible working, however flexible it is decided it's going to be, and, you know, you have, you know, Jawad working with you, you had another trainee working with you previously, how do you see that relationship, that mentor-mentee relationship that has been so focused on them being either sat in the same office or down the corridor? Do you see that relationship changing if it's done virtually, done remotely? And this is very much on the spot. We're not prepped on this question.
No, that's a great question. So that's why I would see the going forward, I do see some kind of balance between the two. So maybe it's the 2 days a week. Maybe it's not 5 days, but we stay at 2 days. Maybe we go to 3 days. I'm not sure. But I do, you know, and it's I think it's really important. What you're saying is that mentor-mentee relationship, it's harder to develop when you're working remotely. Now, but that being said, you know, nothing stops us from just doing a Zoom meeting, right? Like I may end up doing that. I was thinking about that myself, is that maybe every, you know, on the days we're working remotely, maybe every day at 10 a.m., you know, just let's get on a Zoom meeting. I mean, what's the difference, right? Like, what is the difference? I mean, we're all sitting here. We might as well be sitting in one room together. There's not much difference. So I still think that you can still have that mentee-mentor relationship, you know, with maybe Zoom meetings. But I also feel like, yes, you do need that meeting in the office, and to a certain extent, you still need it.
Yeah, I think it's going to be an interesting one to see how that plays out, because you do sometimes glean a lot and learn a lot of information just by overhearing one of your colleagues on the telephone and things like that, which you can't really replicate as easily virtually on doing that. Or maybe you can. Maybe it's just different technology that we're not using, and maybe that's one of the things going forward that we'll learn is about different technology we use. But my next question is, what advice would you give young lawyers or junior lawyers entering the Canadian market who are looking for commercial litigation work right now?
So I think I'm going to answer, I think Gurpreet had a question at the beginning.
Mm-hmm.
And he was saying that it was hard for him to break into the commercial litigation space, right?
Yeah.
Have I summarized your question, kind of?
Yes. Just to give you a little bit of background, like at this.
Sorry, I didn't mean to, Shimon, cut your question off, but I thought maybe because it's kind of can be more specific to the members here. Go ahead, Gurpreet. Oh, we lost them.
Oh, I think we might be having tech issues, Gurpreet.
Is it better now?
Yep.
Yes.
My Wi-Fi is giving me a bad time. So I'm working with a real estate firm doing most of the real estate transactions right now, because that's the only thing came my way and I had to take it. And initially it's like as you rightly said, that it's the foot in the door that I am practicing in Ontario. I'm a practicing lawyer working with a firm, that gaining that kind of repo, but getting that commercial litigation role as a lawyer with a firm who's asking for somebody with 2 or 3 years or 4 years of experience, it's very difficult for somebody who's practiced litigation for 10 years. Like, you have those trial experiences, which are transferable skills. Like, whether you're doing a trial in India or you're doing a trial in Canada, it doesn't make a difference, right? It makes a difference, but your strategies and your thought process remains the same. But what the employers or what the firms are looking for is 2 or 3 or 5 years of experience in Canada. So even though your skills are transferable, they are not appreciated, or maybe this is not the right time, or whatever it is. So my question was, what advice would you give for somebody who's looking specifically for those commercial litigation roles, but is always let down because he doesn't have or she doesn't have a specific experience in Ontario
Right.
in commercial litigation? Yeah.
So you're doing right now purely transactional law.
Transactional law and business development for the firm. That's it.
And business development. Okay.
Yeah.
So I know I don't usually like to tell this to people, but this is what I did. And I tell you, I came from, you know, a decent firm in New York, getting paid 6 digits. You know, I was in a very good position in New York City, but I knew that if I don't get myself, you know, my foot in the door, because right now you're getting all transactional experience, but you don't have any litigation experience at all. So you need to find a litigator somewhere. It doesn't have to be a litigator with 20 years of experience with a large firm. It could be a litigator that has 5 years experience, and just say, listen, you know what? I will volunteer my time 1 day a week with you, you know, 2 days a week. Or maybe I'll just work for you at, you know, I don't know, make a pitch, you know, just whatever it is, like minimum wage. I don't know what it is, for like a month, for like 2 months. You know, I'll give you my time, some of my time, you know, a couple of hours a week or whatever it is. But you have to start getting that experience in litigation, because if you keep building experience in transactional law, you're just, the one thing about Canada and North America that's very different from more of the Eastern, like the Eastern world, and is that here the corporate, like the litigators and the transactional law, there is really a split. You don't see litigators doing transactional law. You just don't see it. You don't see, it's rare. I actually knew a couple of partners at Gowlings in my old firm, and I was surprised they were doing both. But I was like, wow, it's very rare. All the rest of the people, they were all doing, you're either a litigator or you're a transactional lawyer. Like I have a big file right now. I hired a transactional lawyer to advise me on the litigation, like on the transactional aspect of this litigation, because there's a buy-sell agreement in the litigation itself that we're trying to enforce. So it's there. I get it that you feel like, okay, you got your foot in the door, yes, but you're heading towards another path right now, Gurpreet. You got to get litigation experience. And
that's my question was like, how to get that? How I'm trying to get aligned with lawyers who are sole practitioners doing litigation and need some help with research or drafting records, motion records, drafting factums. I'm helping them, but obviously my contract with the employer has exclusivity, right? So I cannot work with somebody else. So either I leave this job and look for commercial litigation altogether, start my own firm, which doesn't make sense at this stage of my career. I don't know much of people. I'll not get that much referral work. So get the foot on the door for a commercial litigator is a difficult task. That is what I believe. Maybe it's due to COVID and maybe whatever the reason is, but that's
how long have you been looking, Gurpreet?
It's been 4 months.
That's not that long. You're basically looking at the worst four months ever. You've been looking literally at during the worst 4 months.
Exactly. I understand that. Yeah.
And sorry, can I ask what firm the transactional work you're doing? What firm you're doing it?
Prudent Law.
Where are they based?
Mississauga.
Okay, and all they do is transactional?
They have litigation as well, but they have defined my role as a solicitor. I've requested them for the litigation work or some kind of my 2 cents on every file, but they've denied that.
Yeah, you see, I had the same thing too. I mean, I hear your pain. You know, I remember at one point even at Gowlings for a while, like they said, okay, well, you're gonna do this type of file, this type of insurance defense file. And I wanted to do more, pure commercial litigation files. And I remember for like a year and a half, they're like, no, you can't do anything else. That's it. We pegged you here, right? It's very difficult to say, well, hold on a second. I had to wait for the right time, for the right file, for them to get a bit busier to slowly transition actually.
Yes.
Out of that. And actually, that's probably one of the reasons why I ended up not working at Gowlings anymore, because actually they didn't give me as many pure commercial litigation work that I wanted to. So I ended up having to, not work there anymore. And so I hear your pain. It's not going to be easy. It's great that you're working somewhere right now, but if you truly, in your heart of hearts, you're a commercial litigator, then you got to have to find a way to get that experience, no matter what. Like, and the problem is also the more commercial transactional work you get, the more likely the next employer is going to say, well, look, I mean, your resume says 5 years of commercial, transactional law. Like, you're not going to.
It's a vicious circle.
Yeah. Gurpreet, stay in touch, okay? And let me know how your progress goes, okay?
Okay,
4 months is early. Stay in touch, please.
No, for sure. Thank you.
Yeah, and I think that goes for everybody as well. I think for anyone who's looking at the moment, this is a weird time. People are they're not looking in the same way. A lot of firms have put hiring freezes or temporary hiring freezes in place. So use this time to connect with people, reach out to them. The assumption is everyone's looking for a job, given, so don't worry about that. Everyone knows you're kind of looking for a job, but just reach out to them as a human being. and make those connections. And then when they do start hiring again, then you're one of the first people in there. And maybe something you could do, Gurpreet, is if you're not already, join the Trial Lawyers Association in Ontario if you're not already a member, because at least then you're meeting more litigation-based lawyers rather than just solicitors.
Yes.
And then you're going to hear about more opportunities. And then the tips that Sam suggested of like reaching out and offering to work with people. I mean, if they're busy like Sam is, they might want to take somebody on a contract basis, a short-term basis, to get them through the hump. And maybe, you know, it's not a full-time, it's not a permanent position, but maybe that's your next stepping stone possibly for you.
Yes, and then offer that to most of the people I speak with, because it's okay. I leave my full-time job only for that one hearing. I don't mind that, because I need to get that experience. It's been 3 years I've not been into the court, and I miss that. So obviously I would leave that job for a contract job or here and there volunteer jobs if somebody wants me to research or something. But I should have something going before I leave what I already have, right? Even if it doesn't pay me, that's fine. But I'm gaining experience. Yes, that is the most important thing for me right now.
Yeah, I'm a big believer. I mean, if you have something that you're working, just to leave it, I would not recommend that. If there's nothing else that you're landing, you know, there's like, I think a Chinese proverb, sometimes you got to take the donkey to get to the horse. Like, you get off the donkey, you're going to have a really hard time finding that horse.
Yeah. Yeah, I agree. Yeah.
Absolutely. Well, Gurpreet, I hope that helps. Sam has offered to stay in touch, so please do connect with each other after the session. So that you guys
We got connected over the LinkedIn this week, I guess, and we'll take it forward from there. Yeah. Thank you so much.
Perfect. So does anybody else have a question? Because get writing it in the comments box, and then we'll come to you next. And Sam's just going to give us a little update on what Global Lawyers of Canada Ontario has in the works. He's going to share some news with you. So over to you, Sam.
Sure. So I don't have the dates. You know, it's been a busy day right now. I have a big deadline tomorrow, and I don't have the dates. But I know that we had the mentorship program, and it was supposed to start a couple months ago. And essentially, the way the mentorship program was supposed to work, where it was supposed to be small groups. It's called the Small Groups Mentorship Program. So you had one mentor, and I think it was 3 mentees. But obviously because of COVID, I think it was supposed to start in March, end of March maybe. And because of COVID, it actually got delayed. But it's going to get restarted, I believe, in September. I don't have the exact dates. So whoever applied for that mentorship program, you know, we apologize that it hasn't actually started, but it will be started. They're reformulated, and it's going to be all virtual now. But it should be starting in September sometime. So if you're interested in that program, do get on the website and you know, put your name on there. It is going to happen, but it's going to happen in September now instead of, I believe it was supposed to start in March.
Absolutely. So that's glcanada.org. And if you go on there and search around, you will find the link to the GLC Ontario Small Groups Mentoring Program. And they are accepting applications from mentors and I believe mentees. So you've still got time to take part. So that's for Ontarians on that one for you. Any other great news, Sam, that's coming out?
Not that I can think of, but if you want, I can answer some of these questions.
Let's do it. Who has a question? Raise your hand.
Or some of the questions that I see here on the side. Is there anything we didn't answer?
I think we've kind of been going through them. We've been
Angela, you had a question about no subpoenas? Oh, I see. Yes. Okay, you already answered that, Siobhan.
Yeah, we were going through answering some of the points as you were talking.
Okay, I just noticed that now. So
in relation to subpoenas to document exchange. Yeah, here it's a much more amicable process. You submit a list of documents and the other side hands them over unless they're privileged, and then you have a big discussion on whether they should be privileged or not.
Exactly.
So lots of discussion around privilege. So for anyone who's studied the privilege rules in university and you're going to be a litigator, you're going to need to know those rules. So get comfortable with them on that one.
So like you don't have to, like, what if they say no? Like when you say if you like have a disagreement, you discuss, like, how do you discuss? Do you discuss in front of a judge?
So Angel, what's your I guess like, are you an NCA student? I just want to know, like, what's your experience?
Oh, sorry. I'm a practicing attorney in Baltimore, Maryland, in the US.
Oh, cool. So, and how many years have you been practicing?
I think it's my 3 years now. Oh my gosh. Yeah.
3 years. Wow, cool. So, yeah, so basically we have what we call the Affidavit of Documents, which basically one representative from the company swears. In that affidavit, they're swearing that they've done a diligent search of all the documents that would be relevant. And these are now all, they're producing all the relevant documents, and they put them in what we call 3 schedules. Schedule A is all documents relevant and will be produced. Schedule B, which is what Siobhan just mentioned, all documents that are relevant but will not be produced because of privilege. And they're supposed to, but not all the time. Sometimes you just see pro forma language basically saying all documents between the lawyer and the client, all like some very generic language that you don't know what they're talking about. But they're actually supposed to provide a very detailed list of the privileged documents and then also why they were not produced. And then Schedule C is the documents that they should have produced, but now they've lost possession of for whatever reason. So by producing that affidavit, under examination, you're then supposed to go through that list and then ask them in front of the court reporter, why is it that they have not produced a certain document? And then you can argue privilege at that time. But most of the time what ends up happening, they don't actually tell you the reason why it's privileged. They're just giving you a list of the privileged documents. If you're lucky, some detail about what those documents may be. And then you're supposed to then ask them for a more comprehensive list, and for them under it's basically an undertaking for them to provide you with a comprehensive list explaining the privilege. And then you can then get a second examination if you want, or by way of just communication through counsel, argue over the privilege and if it's supposed to be privileged, it's not supposed to be privileged. So that's kind of how the system works. We're not sitting in front of a judge, arguing privilege. Unless, of course, we bring a motion because we believe a particular document should not have been privileged and should not have been withheld under Schedule B.
That's very interesting. Thank you. Wow.
Is that helpful?
Yeah. I amicable is not a word that I've heard in a while in a legal setting.
So there's less actual, this is one of the things I missed about practicing in New York. So there's less court practice, I would say. There's less even motion practice in Canada, because in Canada, every side pays. The US, every side pays. In Canada, the loser pays. So most of the time in Canada, we're scared about bringing a motion because we don't want to pay. I should turn the lights on here. It's getting really dark. We don't want to pay the other side's costs. So in Canada, most of the time, it's definitely more amicable because we end up actually settling a motion before it's even brought. So we just basically threaten the motion, and the other side we just go through the discussions and why you're going to bring that motion. And most of the time I think I lost you guys here.
No, you're still here. We can still see you.
Okay. So most of the time we're not actually bringing motions at all because we're afraid of losing the motion and having to pay costs. So, but in the US, because each side pays, it was way more fun when that happened, because people just brought frivolous motions. They're like, we lose, it's okay, it's not a big deal.
Right, exactly. Wow.
And also here it's they do, the whole undertaking that we all take as lawyers is that we act amicably rather than on a contentious basis. So that's an underlying principle for practicing law across Canada as well. So when you go into every situation, you have to come into it from a position of amicability and cooperation rather than coming at it from a contentious litigation viewpoint. And you'll be negatively penalized in court if you haven't shown you've tried to do this at the outset. So I think that underlying principle definitely guides some of the ways that the interactions happen on that as well.
Yes.
I don't know why not everybody lives in Canada.
It's a question we ask a lot of people.
In Canada, we have this thing where it's called sharp practice. And just the allegation that you have committed sharp practice alone is like, it's like a big thing, you know? It's like, oh, you've committed sharp practice. And we're supposed to be like so appalled by the other guy telling us that you've done that. You know, in the US, you'd be like, who cares, man? Sharp practice, whatever, man. You know, it's not a big deal. But here, just that mention of the word is like, whoa, it's a big, it's definitely less litigious and definitely more cordial up here.
That's amazing.
Is there a formal pre-action protocol before you start? Is there a protocol you have to follow before you actually start litigating? Because when I was back in UK studying civil procedure, there was a well-defined pre-action protocol that the lawyers had to kind of adhere to. And also there were options of giving off between the parties, because it is not.
Oh, you broke up.
Can you hear me now?
Yep.
Yeah, I can hear you now. Sorry, the protocol.
Okay, sorry.
To what kind of protocol of what? I didn't understand your question.
Sorry, back in the UK when I was studying civil procedure, there was a pre-action protocol. So that is the protocol which is within the civil procedure code that the lawyers have to adhere to before starting litigation. So basically that means trying to solve it outside the court, giving reasonable offers to the other party. And if the reasonable offer is not accepted, then you get penalized at the end of the litigation when you disclose it before the judge. Is there something like that in civil litigation in Canada?
So there's nothing like that pursuant to statute, but there is something like that pursuant to many contracts. So you actually, as a commercial litigator, what we often do before we start litigation, we'll go to the contract that's binding the parties and we'll look to see if there's a pre-dispute requirement process that you have to take. For example, the CCDC contract, most of the construction contracts actually, I believe so. As other CCD, another one similar to it, has something like that. So you go and check. So we'll say, like, if a dispute occurs, then you'd have to go to, for example, the I think it was like something like the consultant involved. You talk to the consultant, and then you get the consultant to advise you on whether or not you should move forward. And if and yes, so there's these steps pursuant to contract, but it's not pursuant to a statute.
Even I guess the new Construction Act has a mandatory adjudicator prior to the litigation, I guess.
Yes, very good point, Gurpreet. Exactly. Yes, exactly. That's the new Construction Act. I haven't actually practiced under the new Construction Act, but it's only been around for a couple months now. But yes, you're right. You're right. Yes, it would. Although actually, you're not required. You can use it, but you're not required.
Okay, I thought it's a mandatory requirement.
You know what? I was having a discussion with somebody recently, and my understanding is, you know what? I'm not going to say either way, but my understanding is that it could be used but not required.
Okay.
But it's a great system to resolve construction disputes. I mean, if I was advising my client now, I probably would have them go through that system.
Exactly. Yes.
But that's the first codified version of the pre-action in the UK. Now, the pre-action in the UK applies to any kind of litigation.
Yeah.
It's very, very well defined. There's a whole bunch of steps you must follow, and if you don't follow them, you're penalized heavily for it. But no, the Construction Act is the first codified version here in Canada, as far as I'm aware as well. And it is very new. So if you are looking in commercial litigation, go read it, because all of the litigators out there are learning it themselves as they go. And there's some added value that you can bring to them, because you're a student who's newer than they are. So therefore you're supposed to know these things because you've been learning them at school. It's why they bring one of the reasons they bring juniors on board is because you're more up to date on the new rules and regulations, and you can teach the old guard who are in the offices on that one.
Is there a pre-trial mandatory settlement step as well? Like before going to trial, you just offer a settlement, both parties try to resolve it rather than going to the trial, or is it just they do it out of courtesy?
So there's definitely all kinds of steps before you go to trial. I mean, that's why 98% of all claims end up getting settled.
Yes.
Because there's so many steps along the way, right? In certain jurisdictions, so Toronto has a mandatory mediation. Of course, there's going to be pretrial. So every commercial litigation, even any civil litigation, has a pretrial. And in fact, it's not uncommon that you have 3 pretrials. I've had files where there's 3 pretrials before the trial, like but those pretrials, they get closer and closer to the trial. So you'll literally have, a trial 2 months from now, and then you'll get one pretrial like 2 months out, and then 2 weeks before you'll get another pretrial. And I literally had a day before the judge is like, okay, one more pretrial. I'm like, that's it, man. Like, we've had 3 now. Do we need more? But because judges really don't want to have these tried, and the court systems are so busy, and I wouldn't be surprised now with COVID, they're going to be pushing these pretrials.
Exactly.
They're
Yes.
going to be pushing them. They're going to say, you know what? We get it that you guys have been gearing up to trial, and especially commercial litigation, it's all about money anyways. Like, what's the number? Let's just figure this out.
Exactly.
Definitely. So Jawad, I think that kind of covered one of your questions, I think, possibly. But you had another question.
How prevalent is arbitration as a dispute resolution mechanism in Canada for commercial contracts?
That kind of ties in with the question that was asked regarding the pre-action protocols. But I think the UK pre-action protocol does not necessarily compel the parties to get into arbitration. Arbitration is a separate dispute resolution mechanism in itself. So how prevalent is that in Canada? That's what I want.
So the prevalence is depending on the area of law. So there's certain areas of law that arbitration are very prevalent, and certain areas that are not. So off the top of my head, I think I'm pretty sure, and if somebody corrects me if I'm wrong, but I thought franchise law has arbitration clause in all the franchise agreements. I could be wrong, but there's certain type of agreements, they have arbitration clause. All of them have the arbitration clause, and it's just a standard clause. So it depends on what area of law you're practicing. I know securities, but that's from that's my New York practice. All securities actually contracts for, basically if you're buying any stocks from any brokers, they all had arbitration clauses in there.
Yeah, some do. I've not seen them in all of them, but they have alternative dispute ADR. They have different types of ADR in there, so it might not just be arbitration, it might just be other ways of doing it to try and avoid court costs, basically.
I guess you rightly said earlier as well that in CCDCs, there is always a clause for ADRs, and then you go into the litigation.
Yes.
Yeah.
And I think it's a great idea. I mean, I kind of like that.
Yeah.
When I see those clauses, I'm like, okay, good, because you don't want to be running to file a claim right away. It's good to be able to resolve these things early on. So I'm a big fan of having those in there. Although there was certain, depends on the jurisdiction too. I think maybe you may have heard of the Uber case recently, there was a decision on Uber where they pushed them through an ADR process, but I think you had to show up somewhere in Sweden. And so I think the court, I'm pretty sure the court was struck that down, and because that's not fair to be pushing, and ADR is supposed to make things easier, but now you're pushing this, this poor Uber driver from Toronto to have to fly into Sweden to do some kind of arbitration. And so some of those arbitration clauses, ADR clauses, I should say, could be struck, but generally I'm a proponent.
Yes, that's why I guess the unconscionable contract portion of the judgment came into the picture. The arbitration clause was unconscionable because of this. Yeah,
that makes sense.
And that's why you have the separation clause in contracts, because even if that particular clause might be struck down, the rest of the contract will still be valid. And so that's something to look out for when you start looking at contracts, is jurisdiction, methods of remedying whatever the dispute is, severability. There we go, Jawad, thank you. The severability clause. So look out for those clauses. They're typically boilerplate clauses, but as we've shown during a pandemic, those boilerplate clauses have suddenly become incredibly important and are being discussed a lot between legal professionals right now. Things that we've probably overlooked in the past to some degree.
I guess arbitration is one of the great part of commercial litigation, which every internationally trained lawyer can promote, because both Canadian arbitration and I know about India, they come from UNCITRAL mode. So their origin and everything is pretty similar. And I guess the intent is quite similar as well. So that's the area we already have practiced. We know how things work there. So I guess that's a good thing. That's a good practice to have and promote while you're promoting yourself in Canada.
Absolutely. And you know what? That brings us to a great question that Jawad asked, and then we will get to yours, Sonia. Is Jawad, do you want to ask your question about the international interjurisdiction bit?
Sure. I'm just going to read out what I wrote. How much work do Canadian lawyers do in the interjurisdictional/international sphere? Is there room for Canadian litigators to improve or grow or develop in that direction?
It's a good question. So, as a litigator, you probably know, Jawad, you're usually pulling the file to one jurisdiction, right? There's usually like a jurisdiction fight. So, because I have a New York degree, and when I came back, so I have double license. When I came back to Ontario, I thought, oh, great, I'd be able to do litigation on both sides of the fence. But in reality, what you see in practice is that you're trying to actually pull the file to one jurisdiction versus another jurisdiction. So I haven't seen as much interjurisdictional, I guess you can call it, where you're practicing on both sides, or somehow you're using 2 degrees at the same time, if that's what you mean by your question. But in terms of interjurisdictional, I mean, in terms of like having a lawsuit against, another country, I mean, I'm approached potentially suing banks in Europe. I've recently been approached of suing banks in Europe because of Lebanese nationals having their finances have been frozen. A lot of Lebanese nationals, their finances actually been frozen. So I've been approached by individuals to sue banks, potentially sue a bank because they're connected with this other bank in Lebanon potentially. So there's all kinds of issues like that are going to come up. But I got to tell you honestly, I haven't seen a lot of lawyers, Canadian lawyers, practicing on, and I worked at a very big firm. I worked at Gowling. So if I would have going to see those lawyers, I would have expected to see them at those bigger law firms. I didn't see many of them. But now, Jawad, that doesn't mean if you don't see it, it doesn't mean it's not possible. maybe that is an area that we should be growing. That is an area that we should be promoting ourselves in, right? Because we're Canadian. We're like the people that should be like, you know, passe-partout, right? We should be like, we're very international. We're maybe, you know, in some ways we should be able to promote that that area and that kind of, that brand ourselves as like international lawyers. And it doesn't mean that just because it's not being done, it cannot be done. So, you know, I'm very open to suggestions on how to, you know, how to open up that area, or maybe if there's certain associations that, you know, we should be part of, then maybe approaching these associations and, you know, take it from there. I should also add, there's another, that I do have another file that potentially is in the pipeline that is very much on the international sphere. But I am basically going to be partnering up with a London firm, because the London firm has more arbitration experience, and I forgive me if I don't remember the name, but I think it's the Commercial Court Arbitration Court, the International Commercial Arbitration Court, and it's based in London, and the contract actually requires that type of arbitration. So that should be interesting. That's probably something that I'll be working on next year. And yeah,
I know there are many firms who are specifically focusing on enforcement of foreign decrees. So maybe that's where the interjurisdictional work might come into play. I don't know.
Enforcement of, sorry, Gabrit, what?
For foreign decrees, foreign judgments.
Okay, but that's okay. That's a little bit different though, because that's you're just landing. And I've done that. You're just landing a judgment from a foreign jurisdiction in an Ontario court.
Yeah.
You don't. It's not really interjurisdictional. You're just taking the judgment and you're just basically landing it in the Ontario court. And essentially, and it depends on which other jurisdiction. In terms of like some jurisdictions like the U.S., it's very easy. It's pretty much there's precedents out there. We recognize all the U.S. judgments, and so it's very easy just to land it in Ontario, and basically you'd be duplicating the same judgment, but now through an Ontario court. Again, it's not so much interjurisdictional, because you basically then just need to understand Ontario law and how to land that judgment in Ontario law, in Ontario courts.
Yeah.
Okay. Hopefully that answers your questions, guys. We're going to open it up to Sonia. Do you want to unmute yourself, Sonia?
Okay, I'm just going to go back to my question.
Sure.
Which I didn't even realize that I sent to you and not to everyone. But anyway, my question was, are courts still doing virtual hearings, or have they moved back to sort of the normal format? And what is the likelihood of courts having a virtual component in the future?
So I think actually Siobhan, you asked me that question, so I remember. I don't think I answered it. So yes, so we're doing, everything is by phone or by Zoom. So I'm amazed by how, like, literally, I remember the first month it was amazing, because you could email the court and the judge will call you within like 3 days. It was like I was like, what? So because everything, like right after COVID, it was all just emergency motions that were being heard. So I literally would email the court, and like within 2 days, the judge on the line, he's like, okay, we're going to have a hearing, get the opposing counsel on the phone, and we're talking to the judge, and we're trying to figure things out. It was actually great. It was a great experience. Moving forward, I have a big hearing coming up. It's going to be virtual. It's going to be through Zoom. So it's a pretty major, you know, like a very dispositive hearing on some major issues, and they're doing it virtually through Zoom. So I suspect that that's going to be done for the foreseeable future. Will we go back to the courtroom? I hope we do. I love the courtroom. I love being in the courtroom. I love being in the, you know, in the presence of you know, my friends, the other lawyers, and the judges. Do I want to do this all virtually? I sure hope not. But is there room maybe to do it both, you know, have an option if both sides maybe don't mind? Then yeah, let's do it virtually. Why not? I don't see that as a major obstacle, because again, I think you can pick up a lot from just doing it through Zoom as long as you have the visual side of it. I don't like doing hearings by phone. I actually once accidentally yelled at the judge because I thought opposing counsel was talking. So I literally yelled at the judge. It was like the worst experience ever. I was like, Your Honor, I'm so sorry. I thought it was opposing counsel trying to cut me off. So I'm not a big fan of phone hearings.
Yeah, I can imagine that would be weird, especially because as litigators you use body language and facial expressions and reading the room. And Jawad makes a very valid point. That wasn't the sharpest practice.
Yeah. Pun intended, yes.
Yeah, absolutely. I've heard that from a few people where they've said, telephone court is not ideal. It's a very different skill set, whereas at least with Zoom, you can use some of the skills, the soft skills that you've learned along the way. And I've heard that for emergency situations, people have been saying that virtual is great because it can be so quick. As you say, it can be, you can call a judge and they'll call you back in a few hours and you can be heard. So for those like urgent matters. And then I've also heard for more of the more routine matters as well, that virtual might be a useful technique where you can just plow through more routine, where it's less contested. For example, a plan of arrangement in securities law, you have to go to court and get approval for a plan of arrangement. They're on the whole fairly straightforward. It's more about explaining to the judge what it is you're trying to do because they're not security lawyers. And I can see that virtual might be very useful for that, where it's just them reading material and you answering the questions they don't understand and then them rubber stamping in a lot of cases. But yeah, I can see the benefits of both.
Yeah.
Well, the only reason I asked is because they might create sort of a bit more efficiency in, some matters. Because I know coming from South Africa, the courts are backlogged all the time. And you're just always just having like things postponed and like your matter's not being heard because there's just too much of a backlog. So that's why I thought maybe, in terms of like trying to get things done a bit more efficiently, maybe virtual hearings might be.
You're right. It's possible, Sonia. It's possible that will help move things along. Although it's going to be 2 steps backwards for now and 1 step forward, right? Because of all the backlog right now. So I think till the end of the year, there's just going to be a lot of backlog. But maybe next year when they've incorporated the virtual with the physical, maybe they've created a better system where to move things, as Siobhan said, the things that are more just, everyday, not contentious matters, maybe just do them virtually and save the judge's time and the lawyer's time. And ultimately, maybe that's actually would translate into, less expensive, and a better price essentially for ultimately the client, which is better for everybody because there is still definitely, an access to justice problem. And I feel that every day when I'm a commercial litigator, and it's like most people cannot afford the work that I do. Vast majority.
Access to justice could definitely be possibly helped. Definitely possibly. That's a double negative in that instance. But there's definitely opportunities for access to justice to be increased by having multiple ways for people to access the justice system with different price levels and also like physically accessible as well. Because, Ontario is a big province and we've talked a lot about Ontario today, but a lot of the principles are applicable across the different provinces and territories in Canada. And I think, with Ontario being bigger than a lot of countries around the world, getting all the different parties to one courthouse or one particular day at one particular time can be quite challenging. And to have that opportunity to do it virtually could really open it up and make it easier for all parties, which may end up getting rid of some of the antagonism that can be caused by the location between the parties as well, which might make the process a little bit smoother for all parties concerned in that one as well.
I guess the system is here to stay. Like yesterday, I know Superior Court of Justice in Ontario has introduced a new system of class lines where you can share your documents and document storage system. So that the Superior Court would be using that portal for the sharing of documents and storing between the parties and with the judges as well. So I guess they're getting more and more innovative, and definitely they're exploring that this system for small hearings and I would not say for trial, but for not so important motions is here to stay for sure.
I sure hope so, Gabrit, and I think there's so much room to improvement.
Yes.
So just to give you an example, in 2007, when I started practicing in New York, I think it's called PACER law. I think the system's called PACER for anybody that practice in New York, or maybe I think it's maybe just the in the eastern area of the U.S. They all use what we call PACER. And basically, PACER allows you just to upload documents to the court. So instead of filing a document with the court, all you have to do is just literally go on the PACER system and press upload, and that's it. So everybody on that email, and then every party basically has an automatic email alert will go to them and say this document's been uploaded. And it's done. Every single document. We're not filing anything. We're not emailing anything to anybody. All we have to do is just go in the system, upload. Done. That's it. Automatically, that means the other side has it and the court has it. So much easier. I mean, this entire system that we're filing things in the court, emailing people. Why we're doing this? To me, I've now become accustomed to it. Because obviously after 9 years of being back in Ontario, now it's just a standard thing for me. But when I think back to 2007, that system was available. And for some reason, Ontario is not using it. It's very frustrating that we're still filing things and doing things, old school, shall we say. But in some ways, COVID has forced us to go back and rethink these things. So I'm very glad that this has happened. Why should we have to fax something that we could just easily email it? Why are we still using fax? The other day I had to use a fax. I don't have a fax machine. So then I had to go to a friend of mine and get a fax. And I was like, this is ridiculous. Why are we still faxing things?
Exactly.
So in some ways, I want to see these changes done, become permanent. We should not have to go back to faxing things. This should all be done by way of email at the very least, and if not, have some kind of system where everything's just uploaded on a shared drive, and that's it. That's all you have to do.
I guess it's here now because this morning I was reading about Clio, and Clio has some integrations with PACER as well. So this morning I learned about PACER as well. And also,
this is news to me. I didn't know about this. I'm excited.
And Clio also has, I guess, now integration with CaseLine, which is the new system of document sharing in Ontario. So I guess it's all getting integrated, and by the end of the year, we've seen the demerits of COVID, and I guess now the time is to see the merits of COVID.
Yes. Not all the bad things in life come to do you harm. There's a saying, I think it's in Italian. Not all the bad things in life come to do you harm, right?
Yeah.
Sometimes good things come out of it.
Yes.
There's another good way that you guys can add value. Go and read up on CaseLine. Go read up what it is, figure it out, because this is going to be new for everybody. I'm sure BC is doing something similar. I'm sure it's going across. I'm a solicitor, so I'm not up to date with these kinds of things either, and we definitely use fax a lot on that one. And Sonia was saying that she used fax until last year. So yeah, and she didn't even know how to use a fax. You know what? My fax actually goes through my email and my telephone. We moved across, so we actually threw our fax machine in the office in the bin earlier this year, and it was such a fantastic day. We claimed back an entire counter from where this fax machine was.
So you use the software that essentially changes it from an email back to a fax.
Yeah.
from a PDF back to a fax, which is so ridiculous if you think about it, right? Like it's like
it's crazy, but sometimes, you know, that's the only form of delivery that's acceptable. And that's another thing to look for in contracts when you're reviewing contracts, is look at what is a valid form of deliverable delivery method, because especially if it's an old contract, and especially if you're dealing with things like real estate where it may have been written a long time ago, fax was the only method at that point. So it may well still say that fax is still the only valid way to serve notice and things.
Yes, that was my case. It was a lease. It was an old lease, and it was during litigation, but I wanted to send them a notice that they were in default. So I looked at it and I'm like, fax. I'm like, oh no, I gotta send a fax now.
Yeah. Yeah, the crazy things you find, especially in litigation where you are quite often litigating, you know, long-term documents that have been in place for a long time. It's not that they were written maybe 2 months ago or 3 months ago. You know, they could be, you know, 20, 30, 40 years old, some of these documents. Gurpreet has just shared a link in the chat. If you're watching this on demand, it will be in the about of this video, and we will include the link there under resources. You'll find it, so just scroll down on the about bit and we'll share this, which is from the advocate. So Gurpreet, thank you for sharing that with us.
Thank you. Yes, thank you. Great.
Sounds like, well, one of you guys can read this tomorrow and tell me what it says and what we have to do.
Yeah.
Cool, yeah.
Jawad, add it to your to-do list. On that one. So I'm very conscious of the time. I know it's getting late out on the East Coast, and it's especially late for those of you in other countries right now. Does anybody have a final question for Sam? Can be a final question from one or two of you. If you do, speak now or forever hold your peace. Okay, everyone is holding their peace. Sam, do you have any final remarks for everybody here and anyone watching on demand? Do you have any tips? Like the one thing you wish you'd known?
Just generally, if everybody's, you know, anybody out there is kind of looking, I kind of said this before, but I think September is going to be a busy time for litigators. So if you can put yourself out there as somebody that's willing to kind of work, maybe on a doesn't have to be full-time, maybe kind of more temporary, kind of assisting somebody, you know, on a temporary basis. I think, you know, that's a great idea as well, because it's going to be a time of uncertainty, right? Like people don't know what's going to happen come September, October. They're going to be afraid, are things going to slow down again? You know, is there going to be a second wave where things shut down again? So, but if you can put yourself as somebody that's, you know, very eager to help, maybe on a temporary basis for now, I think a lot of people are going to be open to that at the middle to end of September. I have no idea whether there is going to be a second wave or not, or what's going to happen next. But I think that just, yeah, that's a small tip.
That's a great tip. There you go. Use this time now then to build those connections, create those foundations for those long-term relationships. And then they could lead to these potential opportunities through uncertainty, which sounds incredibly weird. That in uncertainty, you're going to find opportunities, but there really are going to be opportunities. And I feel that, and I think Sam would agree with me, that as ITLs, you are incredibly versatile, you're incredibly resilient, and I think you will take advantage of those opportunities that are going to appear. So just keep yourselves open and available. And thank you so much for joining us tonight.
One more tip.
Yeah.
So I actually read this great book called The Guerrilla Marketing for Lawyers. All right. I'll save you guys the read. There's one really good tip that I always give people. For anybody looking for jobs out there, if you're sending out an email to anybody and that email doesn't say in the heading, I know this person, even if they happen to just know them by passing, they don't have to be friends with that person. Just all it has to say is that I know this person and that person mentioned that I should speak to you. Your chances of getting a response go up by like, I don't know, 1,000%. So very, very important. I read the book, great book. but that is probably the most important takeaway from that, and just so important to keep in mind. So as Shaban's saying, make those connections between people, because even if that person doesn't have something that, you know, an opening, most people will not have an immediate opening, but just by them actually able to connect you to the other person is so important as you're building your network. My final word.
No, you know what? And I couldn't think of a better way to end this session. Sam, thank you so much for everything. Thank you for everything you are doing for the Ontario chapter and for GLC in general.
Thank you, Siobhan, for everything you're doing. Thank you so much.
Oh, you're welcome. Guys, next week, we have a session next week. I will be doing it live from Banff. Beautiful Banff in Alberta.
Cool.
I am taking a vacation within Canada. I am house sitting, so it's going to be completely okay. Please join us next week. We have another great speaker. I can't remember who it is off the top of my head, but if you go to our Facebook pages, you will see pinned to the top of each chapter's Facebook page a post with all of the scheduled sessions we have. There will be a slight break after next week. We are going to have a 2-week break during the NCA period, because obviously you guys are all going to be busy writing your exams and everyone else just needs some time off in August. But we hope to see you next week. If you do have any questions, please do reach out to Sam, myself, any of the attendees here, because you know what, everyone who's attending here is now part of your network. So do go and connect with each other, and we will post this video onto our YouTube channel. We post all of our sessions on the YouTube channel. So do go take a look, share it with your friends, and if you have any comments or feedback, please do send them our way. We love to get your feedback, whether these sessions are actually useful and worthy of your time. But otherwise, we'll see you all soon. Everyone have a lovely evening or morning.
Good night, everybody. Stay in touch, everyone.